I hope. Respondent, claimant, closing arguments. Mr. Lorenzo has the floor.
Thank you, sir. Mr. Chairman, and before I get started, I do recognize, as the court reporters told me before I got started, that I've drawn the short straw, because I am the person that stands in the way of closing today's hearing and all of us moving on to perhaps bigger and better things. And I think the court reporter mentioned a martini, and I can see that in my future as well. So I know I drew the short straw, and I will try to be brief in my comments. But I'll begin where I began yesterday, and that is thanking the Tribunal for the time that they have committed to this enterprise, for the patience over the course of the last 2 days, and for the support that they've provided the parties. I also want to thank my colleagues from Curtis and, of course, representatives from the Dominican Republic. But before I get into the meat of our closing presentation, I feel compelled to address certain of the points, the initial points that were raised by counsel for the Dominican Republic. And the first is actually page 2 of their presentation, their closing presentation, that makes reference to R40. And it's a picture of garbage accumulated on a street. I assume that's a street somewhere in the Dominican Republic. I note in that article, notwithstanding the title that appears on the first page, that it makes no reference to Lajun, it makes no reference to Duquesa, and it wasn't the responsibility of Lajun to collect waste. That was the responsibility of the municipality. I was also intrigued by the idea now that the Dominican Republic takes the position that, you know what, if this particular investor, Michael Lee Chin, wants to be vindicated, and because they have every right as a sovereign to hold the keys to the forum where that dispute should move forward, and given that they, under their interpretation of Article 13, are refusing to allow the door to international arbitration to be unlocked, well, Mr. Lee Chin has every right to go to the Dominican Republic. And I heard my colleague from Curtis note that Mr. Lee Chin has other businesses that continue to operate in the Dominican Republic. That's not true. Mr. Lee Chin is the general partner of a private equity fund that has interests in the Dominican Republic, but his personal interest was this one, the Duquesa properties, and the Lajun concession, and a house in Casa de Campo that, since this dispute crystallized, he hasn't gone to. And why is that? Why is that? That is because, obviously, he has serious concerns with the Dominican Republic, has serious concerns with the rule of law there, and that is why he's prosecuting his claim. Does he believe he has every right in international arbitration? But there is a document, C-122, which is the declaration of Adrian Lee Chin. And in that declaration, Adrian Lee Chin, at page 33, paragraph 91, makes reference to a criminal complaint that was lodged by the government, one of the instrumentalities of the government, against him in his individual capacity. And of course, we all abhor the idea of the criminalization of civil disputes, but that's what happened here. And that criminal querella, I would imagine, remains in place. It was filed in August of 2017, a mere few months after the second settlement agreement was signed, and after the municipality represented in the second settlement agreement that it had no claims against Lajun, that it had no claims against its principles, that it was being operated in conformity with the law, and went so far as to provide a release. So with a great deal of respect to my colleague and a great deal of respect to the representatives of the Dominican Republic, the idea that Mr. Lee Chin is going to have his rights vindicated by a Dominican court, well, I take issue with that. Particularly when Dominican court after Dominican court has taken aggressive and hostile action against this foreign investor. So to allege that somehow that is going to be an appropriate forum, and in fact the only forum where potential vindication can be had, well, they know that that door is not opened, and they know that it's not plausible. And if that truly is the only door, and if the restricted, untenable reading of Article 13 is the reading posited by the respondent here, well, this tribunal has done more than just deny jurisdiction. This tribunal has denied the opportunity for this foreign investor to endeavor to seek vindication, because there will be no action in the Dominican Republic. There will be no redress there. Counsel for the respondent can appreciate that, and I'm sure my colleagues from the sovereign know that as well to be true. And the querella can be found at C88 of the arbitral pleadings. We've heard interesting words to describe a fact witness, to describe who I understand to be a well-regarded former ambassador of the Dominican Republic, and to describe Professor Puellen. Professor Puellen isn't a legal scholar, isn't an expert. He's a contortionist that takes any form necessary to posit the theory that he's supporting here. I think Professor Puellen has been consistent in all of his submissions, and he has been consistent in his testimony here. And his belief is that you need only read paragraph 1, and in paragraph 1 you have consent. And I can appreciate that the respondent takes a different view, and that's fair. But I don't think that it is fair to characterize someone such as Professor Puellen, who authored his expert reports under his own analysis of the treaty and documentation that he reviewed, and came to the conclusions that he came to, and ultimately sat here today in what I believe to be a very forthright, candid, and appropriate cross-examination. So to characterize him as a contortionist, I think is just wrong and not accurate. And also, I believe, that Professor Puellen didn't consider the preparatory works. And these preparatory works, according to the respondent, are so crystal clear that they leave no doubt whatsoever that their interpretation of paragraph 13, or rather of Article 13, is accurate. Well, we all know that we don't have all the preparatory works. That's not our fault, because Mr. Lee Chin didn't warehouse them, didn't store them, never had copies of them. So to try to say that what they have, which we disagree with, supports their premise and should be given some astronomical weight is unfair. When this tribunal ordered that all the preparatory works be provided, and what they provided was what they found after the procedural due date. And what they found, a handful of documents from a handful of rounds, there were 19 rounds, well, those somehow should be given extraordinary weight. Well, we disagree. And by the way, the testimony, or rather the statement that was made by counsel this afternoon, was that Mr. Puellen did not have the opportunity to review those preparatory works. Well, I invite the tribunal to review Professor Puellen's testimony. And in his testimony, or either his direct cross-examination responses or in his presentation, Mr. Puellen made clear that after the submission of his second report, he had the opportunity to review the preparatory works, and that it doesn't change the opinions that he's proffered. So to say that they weren't considered is wrong. And with respect to the fact witnesses, well, Ambassador Zadeh apparently worked on all of these things, and I'll use the phrase that was used by my colleague, with his team. And I understand that Ambassador Zadeh, for reasons that the tribunal is well aware of, chose not to be here. But his testimony is consistent with Ambassador Hilton's testimony. And I'm not going to venture, as my colleague did, to challenge or say that this witness is not credible. That somehow this witness remembers only what he cares to remember. And that it's just inexplicable, unexplainable, that he can recall this particular treaty, this particular dispute resolution provision, notwithstanding that he explained why that recollection stuck in his mind. And he made specific reference to Law 174 or 172 or 173. I'll get it eventually. But I'll leave it to this tribunal, which is experienced, to determine the weight that they will give Ambassador Hilton's testimony. But it struck me to learn of this team of ambassadors a day. Where are they? Where are they? Because one would have expected that if that team truly believed that Ambassador Zadeh was wrong, that Professor Hilton probably didn't remember, forgot, that the theory that was being posited by the claimant was foolish, untoward, absolutely illogical, that someone on that team, el equipo was the phrase that my colleague used, would have come to this tribunal and would have aided this tribunal to work through what has become a quagmire. And why has it become a quagmire? It's become a quagmire because the respondent must hope beyond hope, must fight tirelessly to try to undo Article 13, to try to undo the fact that there is consent in paragraph 1. And how do they get there? Even though we heard in the opening presentation that Article 13 must be read in its entirety. What the respondent asks this tribunal to do is read every paragraph in isolation. The reference to international arbitration in paragraph 1, it's just an option. That's it, nothing more. It's not a forum. They even said at opening that international arbitration in paragraph 1 is not a forum. Local arbitration, not a forum. Local tribunals, not a forum. If they aren't forums, what are they? Words on a page? Words have meaning. Those words have meaning. They also asked this tribunal to reinterpret the word shall in paragraph 1 and provided a meaning that is not the ordinary meaning in legal context. That's defied by legal jurisprudence. That's defied by tribunal decisions that have looked at clauses very, very similar to ours. Shall submit the dispute to international arbitration. They're asking this tribunal to ignore paragraph 2 and the phrase where referred to international arbitration. That doesn't mean really much. And unsatral in paragraph 2, well, it's just an idea. Something that we have to agree to, must agree to. Because if we do not, there is no consent. I asked the tribunal, where is the word must in paragraph 2? There's a may, and then after that may, there's a comma. But again, in order for that theory to survive, not only must may become must, not only must shall become may, but the comma, to utilize their phrase, means nothing, is irrelevant. Just delete it. We don't need to look at it. And I heard in closing this afternoon, and what do we do about paragraph 3? It does use the magic word consent. And who has to consent? The investor. But even though it's in Article 13, And even though from their own mouth they said that Article 13 must be read in whole, I learned this afternoon in the presentation by counsel that just like the comma, paragraph 3 is irrelevant. And what about paragraph 4 that talks about awards? Well, just like the comma, just like paragraph 3, just like IA means nothing, international arbitration means nothing in paragraph 1, just like this tribunal must convert shall to may in paragraph 1, and must convert may to must, not once, but twice, if not 3 times in paragraph 2. Paragraph 4, irrelevant. Don't need to worry about that. All you need to do is make all of those assumptions, make all of those revisions, make all of those changes so that this clause can be appropriately interpreted. Well, I don't believe that that verbal or legal gymnastics needs to happen. The gymnast here, the contortionist here, is not Professor Puellen. The contortionist here is the theory posited by the respondent and the interpretation that they are endeavoring to compel this tribunal to accept. And with that, I'll jump into the body of my presentation. What's the correct interpretation of Article 13? And we're going to try to walk through it, taking a bit of guidance from the idea of Professor Leafley, and that was trying to look at it as a whole, not fall into the trap posited by the respondent of trying to break it down word by word, sentence by sentence, paragraph by paragraph. So let's look at it as a whole. And that idea that Article 13 must be interpreted as a whole sounds like a good idea. I think that's right. But don't take my word for it. Don't listen to Hogan Loveless. Don't listen to Richard Lorenzo. Let's listen to La Doctora Frutos Peterson. And what did she say yesterday? Now, Article 13 must be interpreted systematically as a whole, and its parts cannot be interpreted in isolation. Kudos. I agree. But what are they asking this tribunal to do? You heard the words. The comma is irrelevant. Shall means may, or now apparently it means will. May means must. Paragraph 3 means nothing. And paragraph 4, well, forget about it. We need to look at it as a whole. And we're going to endeavor to do that. And let's go step by step. Step 1. Disputes between an investor of one party and the other party concerning an obligation of the latter under this agreement. Okay. So it's a dispute between an investor and the state concerning treaty obligations of the state. So it's a claim by the investor. Step 1. Let's jump to step 2. And here's some of the magic words. Shall. I know it's crazy, and I know it's unheard of, but we are asking this tribunal, and it's lunacy, to say that shall and hold that shall actually means shall, that it's mandatory. But they have some other words there. Shall be submitted to international arbitration. And we contend that this is the state's consent to international arbitration. Period. Full stop. Well, let's dig a little deeper into the word shall and this crazy idea that we have that it's mandatory. And I go back to Ms. Frutos Peterson. La doctora, I apologize, Frutos Peterson. Grammatically, the word shall may have the connotation of an obligation as well as refer to something that could occur in the future. So in this instance, in analyzing this treaty, shall is not the normal meaning. At least that's the position of the sovereign. Well, what did her colleague say? Well, she said yesterday, or rather today, because we understand the full agreement, and we have spent many hours on this here, and I agree with her, we have, the shall be submitted, those words, are the ones on which we have a different interpretation. Again, I agree. We believe shall is mandatory, an obligation, and they believe shall means may, changing the word. And what respondent wants to do is rewrite paragraph 1 and change shall to may. And I posit to the tribunal, this is not a subtle change. And that change is necessary because they're familiar with the cases that have analyzed similar provisions. They're familiar with those cases. And they know the results of those cases. In those cases, paragraphs such as this, language such as this, is deemed to be consent. And that's the ordinary meaning. The Vienna Convention mandates that this tribunal consider the ordinary meaning. And of course, very helpfully, the respondent invited us to look at Black's Law Dictionary. Always a good source to figure out how to define legal terms. I don't think it's necessary here because I think the ordinary meaning of shall we all know. But since they're asking this tribunal to change the word to may, well, they pointed us to Black's. And we looked at this yesterday, and we even looked at it incredibly again in the closing of the respondent because they can't give this up. Because if they can't convince this tribunal that shall has to mean may, there's consent. So they can't let this die. They're all in. All their chips are in. But we know what the definition of shall is. Has a duty to, more broadly, is required to. This is the mandatory sense that drafters typically intend and that courts typically uphold. Only sense one is acceptable under strict standards of drafting. And can one truly believe that in drafting a treaty such as this, that the drafters were so negligent, so foolish, that they would use the word shall when in reality they wanted to use the word may? And where did this language come out of? Did they make it up? Was it on a lark? No. UNCITRAL Model Arbitration Clause uses the same shall be settled by international arbitration. Well, are they alone? What does the United Nations Conference on Trade and Development say? Dispute settlement, international settle for settlement of 2.3, consent to arbitration. Wow. Exactly what we're talking about here. Consent to arbitration. What do they say? Some bits do not specifically mention consent. This one does not. In paragraph 1 or paragraph 2, it does in paragraph 3. But formulations to the effect that a dispute shall be submitted, our language, leave no doubt as to the binding character of these clauses. We agree. The respondent is asking this tribunal to rule the contrary. Garanti cosa. And I appreciate that the respondent, la doctora Frutos Peterson, has issues with this decision. And like any decision in the academic world, people can take issue with it and have contrary points of view. But it's a decision nonetheless, and it's a tribunal that's well regarded, and they looked at this question of shall. It's not an argument that hasn't been made before. And in the Garanti case, looking at a paragraph 1 and a paragraph 2 with language very similar to ours, in particular with respect to the word shall, what do they conclude? The use of the auxiliary verb shall makes the statement mandatory. As the tribunal in Wintershall versus Argentina put it, the use of the word shall is itself indicative of an obligation, not simply a choice or option. We agree. This is not setting a legal precedent that is outlandish or insane. It's the ordinary way to apply and interpret a word. But does the tribunal stop here? No. They say the word shall, in treaty terminology, means that what is provided for is legally binding. Legally binding. And I understand that this tribunal's view may be criticized. But I would be surprised if a legal scholar would criticize their analysis with respect to the word shall. I would be surprised if a legal scholar would say, you know what? Shall truly doesn't mean shall. Let's go to section 3 of Black's Law Dictionary and let's convert shall into may. But let's test a little more of this shall because it is a linchpin in their theory. Y la doctora Frutos Peterson yesterday said, therefore, bearing in mind that that paragraph talks about 3 alternatives for the settlement of disputes, the term shall cannot be used in this provision as an obligation because such an interpretation would lead to the absurd situation of considering that the same dispute will simultaneously have to be submitted to 3 distinct methods that are cited, bless you, in paragraph 1. In paragraph 1. And I understood, candidly, much like the chairman of the tribunal, that this wasn't just an absurd idea, but this was actually the idea, that this is how the only logical way of reading it. And I know the chair pressed for an answer, which we finally got today. But where would that leave us? Well, under the initial theory, analysis, which is now morphed into something different, well, that would have required further changes to paragraph 1. Change shall to may, and change or to and, not once, but twice. Not subtle, I think significant. But it goes on. La doctora Frutos Peterson. Furthermore, in international law, there is nothing understood as being an abstract consent to international arbitration. As Claimant is attempting to make use, believe because the consent of a state must be specific to the forum. Not a set of rules. UNCITRAL rules. Not a forum. And quite clearly in this first paragraph that you have before you, there is no mention of a forum. And I believe La Doctora Frutos Peterson was being deliberate because she doesn't use forum once. Perhaps it was a slip of the tongue. No, she uses it twice. Okay, let's look at the clause. Her contention is in paragraph 1, there is no reference to a forum. Well, candidly, I disagree. I think logic disagrees. I think legal precedent disagrees. I think a court is a forum. I think a national arbitration, a forum. I believe international arbitration is a forum. So to say that there's no consent because there's no forum belies the reality, the language of paragraph 1. And I go back. Words matter. Language matters. We can't just modify it to suit our own jurisdictional purposes. Elimination of paragraph 1. In conclusion, La Doctora Frutos Peterson provides, or stated, it is not possible to support that paragraph 1 of Article 13 contains consent to international arbitration. And you know what? She may be right. If all of those assumptions that she's mandating come into play, that there is no reference to a forum, which there is, that or means and, that shall means may, and that all of the legal jurisprudence that supports that analysis goes away, is deemed incorrect, frivolous, flawed, wrong, that Black's Law Dictionary doesn't know what it means, and that shall means something other than shall. So let's jump to paragraph 2. We've talked about step 1, we've talked about step 2, the state's consent to international arbitration. And here, in step 3, where the dispute is referred to international arbitration, the investor accepts the offer of consent set forth in paragraph 1. And here's an exchange with the president of the tribunal. And here, interestingly, this whole idea of forum and the fact that there is no forum, I think, in a moment of clarity, was put to rest. And the chairman asked, but as you said, you say the fact that it contemplates these 3 alternatives would lead us to having to initiate arbitration in these 3 fora. The chairman understood that these are not just things, these are forums. But I think it only refers to initiating arbitration in one of the 3 fora. Again, fora. I need clarification on your interpretation. Y la doctora Frutos Peterson provided that clarification. And she said, were it mandatory, I think it should be deberían, must. So the text of the article is clear, and perhaps this is not the moment to go into another discussion on this matter. But she goes on. But I think it leaves an option to the investor as to what forum is chosen. La doctora Peterson knows that it's forum. I think he or she has to decide. We agree. The choice is for the investor to choose the forum. And it goes on. And the argument, was posited by La Doctora Frutos Peterson yesterday. And the argument by the claimant is that the consent to international arbitration in the first paragraph can exist without a forum. Now, we now have her admitting that international arbitration is one of the forums. In the first paragraph, can exist without a forum, and that the second paragraph only refers to procedural matters which are to be resolved once the arbitration has commenced. But arbitration where? Well, let's continue to step 4. The investor and the state may agree, there's a comma, which according to the respondent is irrelevant, to 1 or 3 arbitrators. And step 4 is an agreement, with respect or not, on the composition of the tribunal. Now, they discussed briefly the preliminary exchanges between the parties. And this question of how many arbitrators was resolved. And it was agreed that this would be resolved not by a single arbitrator, but by a tribunal of 3. And they designated Professor Cohen. And there wasn't an explicit reservation here that somehow this was something that they were not going to do, that they were preserving, that the UNCITRAL rules did not apply, that this clause did not provide consent. No, they designated their arbitrator. And they agreed that the tribunal would be conformed by 3 arbitrators. They agreed. May agree. They agreed. Composition of the tribunal. It could be, once there is a composed tribunal, which we have in this case, the parties can agree to a special agreement as to how to appoint the tribunal. Appointment of the tribunal by special agreement. Now, If there is no special agreement, we contend that the arbitration proceeds as established under Step 6, the UNCITRAL rules as a default. And that is the phases of how these clauses, these paragraphs, I apologize, should be read. And what leads to this, which we contend, is a logical conclusion. And of course, the interpretation not only must be in good faith, which we believe the interpretation that the claimant has posited is the only good faith interpretation, is an interpretation that provides ordinary meaning to the terms set forth in the treaty, and of course, is in the context and in the light of the object and purpose of the treaty. There is an explicit reference, which they try to delete, carve out, of UNCITRAL dispute. And of course, what does the default of UNCITRAL provide? The mechanism in its rules pursuant to which you can determine the number of arbitrators. And if there's silence from one of the parties with respect how to appoint the arbitrators, the methodology under Article 7 pursuant to which that happens. So looking at the agreement, I apologize, Article 13 in the whole, as the respondent recognizes has to happen, we believe unequivocally establishes consent and unequivocally establishes a methodology for the arbitration to proceed pursuant to the UNCITRAL rules when there is not a special agreement. In any event, the Dominican Republic consented to the UNCITRAL arbitration rules. And I appreciate that there may be una reserva de pleno derecho. There is no reservation such as the one that came after the engagement of Curtis Millay. But the die was already cast. The die was already cast. And we'll broach this issue. La doctora Frutos Peterson. This exchange of correspondence among the parties refers clearly to matters related to Section 2 of the UNCITRAL rules on the composition of the arbitration tribunal, which is contemplated in Article 5 of the rules, which has to do with the number of arbitrators. Well, let's test that. Let's look at their letter of 18 May. Interesting in this, and again, it does have a reservation, and it's a reservation for matters that they haven't already agreed to, unless there's some specific language to the contrary, which there isn't. The Dominican Republic here on 18 May in C-132 provide, jumping to Spanish, aprovechamos para aclarar que en
We clarify here that in this procedure,
here, we're talking about un procedimiento arbitral. Jumping to Spanish,
to which the rules of arbitration of UNCITRAL of 1976 would eventually apply.
Of the fact that it was a default. They knew that if there were no special agreement, these rules aplicarían, which they did. And ultimately, they agreed that those were the applicable rules. But was it limited only to Section 2, as La Doctora Frutos Peterson proffered? We say no. Because the rules were being invoked for, among other reasons, to avoid having to file an answer. And that concerns Section 3, not just Section 2. The effet utile, and I apologize for my French because I don't speak it, so you get what you get. La Doctora Frutos Peterson provided, and we'll take this definition. I can live with it. Let us record that the principle of useful effect, thank you, I like that much better, does not mean to give the text its maximum effect, but excludes interpretation that would make a text senseless when it is possible to have interpretations with meaning. We agree. I proffer that their interpretation in the whole of paragraph 1, 2, 3, and 4 would make text senseless and illogical. Effect utile gives the reference to the UNCITRAL rules, if it's not clear enough, which we believe it is, a purpose. And that purpose is to provide the vehicle, the default mechanism, if the parties are unable to agree. There's no obligation of agreement. They may agree. And they provide a default mechanism to stop the veto that they're endeavoring to create through the argument that they're positing here. And of course, the effect utile of this interpretation of paragraph 2, of course, would provide consistency with paragraph 1. A paragraph that they are desperately fighting to ignore, desperately fighting to change, because they know that it grants the consent that we set forth. And what else do we know about the effect utile? There's a question by arbitrator Leafley to the witness. Was it a change in negotiations, or was it the accomplishment of something that was so memorable to you on this topic? I'm shocked that the ambassador remembered because, according to the respondent, he can remember nothing. But Ambassador Hilton did remember and was in a position to respond. And he said, well, the issue in trying to get a resolution to the problem, and we were satisfied at the end because we had gotten the consent. We believe we had gotten the consent of the DR for international arbitration on any issues arising from the application or interpretation of the treaty. Now, I understand that that language hurts, but that's evidence. Lawyer argument is not evidence. That's evidence. Testimony of a witness is evidence. Lawyer argument is exactly that, argument. And there isn't a witness from the Dominican Republic that was proffered to this tribunal to counter this testimony or to counter this effect utile. And the questioning to the ambassador went on, this time by the president. And the question was, a very last question, are you satisfied with the wording of Article 13? So do you think that really with this wording, the policies you have fixed were achieved? And Ambassador Hilton's response was correct, I am. Compelling testimony with respect to the effect utile. So what is it that they're really trying to accomplish? The respondent. They absolutely want to rewrite paragraph 1. But their theory also requires this tribunal to rewrite paragraph 2. And let's look at the words that were used by La Doctora Frutos Peterson yesterday. Second of all, the phrase may agree in the second paragraph refers clearly to two aspects. The adjudication body of the arbitration, which can be an international arbitrator or an ad hoc body, and the rules for arbitration of the parties can be defined by their own rules for the specific case, special agreement, or an agreement in red to submit the arbitration to the rules of UNCITRAL. Another agreement, more agreements, more must. Well, where's that language in Article 2? I'm sorry, paragraph 2. It's not there. They need to add it. They seek to add it. We contend this tribunal must add it. The comma. And again, using counsel's own words, Article 13 must be interpreted in the whole. Well, there's a comma. La Doctora Frutos Peterson says, truth of the matter is that the comma after the ad hoc is not important. I'm sure if the comma had some significance that would further advance their theory, it would become immensely important. But here, given that it doesn't, it's just another grammatical term, another grammatical reality that we can forget, that we can avoid. Made a must in paragraph 2, Professor Puellen. So when, that's why I think your reading reads may agree as a must agree for a second time. So what the respondent requires for their interpretation of Article 2, paragraph 2, to be consistent with their theory, the may agree that appears once must become must, and then you need another must agree further down in paragraph 2. And Professor Puellen was asking, am I right? Is that my interpretation? Is that my interpretation? Y la doctora Álvarez Villa's response, we agree on that. We agree that I need to change may to must. So what is the rewrite that they're asking? This is how they want this tribunal to read and what's required for their interpretation to be effective. Respondent's interpretation is entirely reliant on language that does not exist in the treaty, seeks a veto power not provided for in the treaty, and ignores paragraph 1. That is not a good faith interpretation. That is not a good faith reading of Article 13. And we contend that ours unequivocally is. Paragraph 3, I spoke briefly about this. And again, investor has consented. Here we have language talking about consent. Doesn't say sovereign consent, says investor consent. We deem that to be important. Professor Puellen noted that it is indicative that consent was proffered in paragraph 1. And what is the response? The response that I heard in closing today is that, like many other aspects of Article 13, this is meaningless. We don't need to think about it. Well, what about paragraph 4? The awards of the arbitrator shall be definitive, compulsory. Again, more references to arbitration. After the consent in paragraph 1, after what we see in paragraph 2, after the investor consent in paragraph 3, more references to arbitration. But like paragraph 3, like the word shall and many other terms, like the comma, this means nothing. Just extra words on a page. And we proffer this is consistent with what we saw and the consent provided in paragraph 1. And what do we know about the decisions, the cases? Well, we heard that again today in closing. La doctora Frutos Peterson said these decisions, Garanti, Venezuela, U.S., are not relevant for the case that we have before us because in those two cases, the clause for dispute resolution contained in the treaties are diametrically opposed to the clause in this case. Well, let's look at that. Article 1, shall. Article 13, shall. Article 1 in Turkmenistan, be submitted. Article 13, be submitted. Where? Article 8.1, international arbitration. Article 13, international arbitration. And the tribunal looked at these issues and said, we look first at whether Turkmenistan has consented to participate at all. And we talked about the burden of proof and whatever standard the tribunal wants to apply. The tribunal here said Article 8.1, similar language to ours, thus appears to a majority of the tribunal to establish unequivocally Turkmenistan's consent. And the tribunal goes on to say, Turkmenistan has consented to arbitrate disputes with UK investors arising out of that treaty. It's a decision, and I can appreciate that the respondents take issue with it, but we believe the reasoning is sound. And they go on to look at language similar to our language in paragraph 2, where the dispute is referred to international arbitration. Where the dispute is referred to international arbitration. And in a section titled, What Kind of Arbitration?, they describe what they view that terminology to be. And they say, we find in Article 8.2 only a menu of options concerning the arbitration process and a default selection. The argument that we're positing here. Consent, as explained in the preceding section, is granted in Article 8.1. Language consistent with ours, we concur with this decision. Is it isolated, an outlier, preposterous? No. There are other tribunals that have looked at similar language, shall be submitted to international arbitration. And I give you the example, CL 62, the Rosinvest case versus the Russian Federation. And there again, there was a jurisdictional attack. The respondent argued that the UK Soviet bit does not contain an offer to an investor to arbitrate a dispute, and that it requires a joint referral. The tribunal there, similar to the case that we just saw, looking at Article 8, says that the language is express and unambiguous language, and that the word shall is mandatory. In short, the tribunal goes on, the other party does not have to agree again in order to permit the arbitration, and that this is language that is used and found in multiple bids. They're asking this tribunal to go counter to what many tribunals have already resolved with respect to the word shall and with respect to language similar to that which is set forth in Article 13. So consent has been granted. And this matter should proceed promptly to the merits. There was a graph, a chart, that I guess was presented to leave the impression that somehow we too were contortionists, and that our theory changed with the passage of time or the blowing of the wind. Well, we went back. And maybe we didn't say that there was consent ab initio in paragraph 1. Maybe I forgot. Well, we went back to the notice of arbitration, and we say that there was consent as a result of paragraph 1. Letter to the tribunal on the 3rd of October. We make the point that there is consent given the word shall, serán. Well, we're still not changing our theory with the blowing of the wind. Well, what do we say in the opposition to respondents' request for bifurcation? Well, shall, será, in paragraph 1 provides consent. Well, maybe we changed our mind in the counter memorial on jurisdiction. No, we didn't. Remains the same. And finally, in the rejoinder, maybe this is when finally we found the Holy Grail, because our co-counsel, Professor Puellen, told us that this was the right idea. Nope. Same theory of consent, same argument from day one. Indirect investors. And there was a question posited by Professor Cohen during my opening, and I wanted to address that question. And it was this issue of every kind of asset, whether or not this clause was sufficiently broad, the treaty provision, to capture indirect investment, given that it is not specifically referenced in the treaty, as posited by counsel for the respondent. And we put on a laundry list of arbitrators who I think are well regarded in the international arbitration community that have not supported the theory that was being posited by the respondent. And again, in their submissions, they say, we recognize these decisions, but they're just wrong, just like the other cases. So don't follow the decisions that have ruled opposite to them, just follow their view of the world now. And Professor Cohen asked us, and they're in the presentation, to list the cases, and we've done that for the benefit of the tribunal. We've provided the case, a quote concerning this particular issue, and the arbitrators that resolved on that. I won't burden the tribunal or my colleagues with going through each and every one of them. They are there for the benefit of the tribunal to review at their leisure. In conclusion, Mr. Chairman, members of the tribunal, we agree with La Doctora Frutos Peterson that Article 13 must be read in the whole. And we agree that the Vienna Convention sets forth the principles pursuant to which this article should be interpreted. Good faith, ordinary language, ordinary meaning, taking its context and object into effect. We believe, Mr. Chairman, and with all due respect to our colleagues and to the Dominican Republic, that this jurisdictional challenge lacks merit, that their interpretation of Article 13 is a jigsaw puzzle, to use their phrase, that mandates this tribunal to change words, give words meaning which are not ordinary, to add language to key provisions, to change language from shall to may, from or to and, from may to must, and to ignore case after case that interprets language just like the language that this tribunal has before it, and to support itself in their theory on dissenting opinions, on outlier cases, to bring about a result which we contend would be unjust, would vitiate and destroy the consent that was clearly proffered in paragraph 1, and that would mandate ignoring the reasonable interpretation of Article 13 and the agreements that were made by the Dominican Republic prior to the engagement of Curtis Millet. Mr. Chairman, I thank you, I thank the tribunal, I thank my colleagues, and I thank the Republic for your time. And we look forward to this tribunal promptly determining that it has jurisdiction, that it awards Michael Leachin the corresponding costs, and that we promptly proceed to the merits. Because this jurisdictional exercise has taken almost 700 days, and many times it's been said that justice delayed is justice denied, and we critically want to move this case forward. Mr. Chairman, thank you for your time.
Thank you very much. My co-arbitrators, well, please go.
Yeah, I'm just picking up my post-its.
Para la segunda para los dos, ¿no?
Sí, exactamente. Sí, son preguntas que...
Vamos a esperar que se siente.
Sí, le dejo 2 minutos.
¿Vos también tienes preguntas?
I have questions which I assume both will maybe wish to comment on, and I will defer to the President as to how the responses and counter-responses may be managed thereafter. I only have, I think, 2 or 3 questions. My first question is maybe focused more to the respondent. And this is about the issue of whether paragraph 1 is enough. And what I mean by that is the reference to arbitration, whether it's sufficient. And I know that Metaltech is cited in a situation of ICSID, and I'm conscious of Ms. Frutos Peterson's response yesterday about the significance of having to consent to arbitration rules. But my doubt that prompts my question is, do you need more in the circumstances of an ad hoc arbitration? Because we're not ICSID here. Ad hoc is a blank piece of paper in many respects. And if one were to have this treaty just as paragraph 1, there could be an argument that the consent, if consent were construed from paragraph 1, would be sufficient, and that the parties would actually be left with the task of constituting a tribunal, which would have to be an ad hoc tribunal, because there would be no rules and there would be no institution. And so that does prompt for me the question that I'd be interested in your answer. Isn't that enough? Now, of course, you can, you don't need a designation necessarily of the number of arbitrators in an arbitration clause. It's always nice to have that. I don't know if you need a designation of a set of rules. That's maybe part of my question. And I am very conscious that I'm borrowing slightly from, in my jurisprudential appreciation, the growing body of case law that is really taken more from a commercial arbitration setting, where if there's a slightest whiff of an arbitration clause, courts are increasingly granting the benefit of the doubt to find an arbitration clause. So I would invite you to police that, perhaps that frailty on my part. So with that, maybe I can leave the question for respondent.
Sí, muchas gracias. Yo creo. Thank you very much. I'm going to split the question in two. First, with regards to the UNCITRAL rules. So if you simply read paragraph 1 in Article 13, it's simply not in the scope of application of the rules. And that is step 1 in order to be able to use them. So for us, it is not sufficient for this tribunal specifically, or any tribunal, in accordance with the UNCITRAL rules, may declare itself to have jurisdiction. The second point you raise, we agree with you. It is an aspect that is seen in commercial arbitrations. Now, here we're dealing with a treaty, with international law, and therefore it doesn't, from our point of view, it cannot be the case. If I may complement to the second part of the answer. Yes, indeed, we fully concur with your perception from the point of view of international commercial arbitration and how a principle of interpretation of consent would appear in a purely private arbitration between private parties. Although it could be with a state, but it's a state in its figure as a commercial entity. So there are theories in international commercial arbitration that may be used to interpret in favor of determining jurisdiction. And that is a problem when you've got investment arbitration, when there have been people who say it's the same situation. But it isn't the same situation because of what my colleague Gabriela said, because we are looking at international public law where we're playing the role of the state, and the International Court of Justice has determined how we have to look at the consent of the state. I would like to interrupt my co-arbitrator on this point because I believe it could be relevant. You'll tell me if it's not the case. Let us go back to investment. Let us forget about commercial and how the commercial area may affect investments. I'm not going to express my opinion in this regard, but in any event, I do believe that they are different things, at least. But let us suppose that in a treaty, it says the states or the parties to this treaty give their consent, irrevocable consent to international arbitration, period. It says nothing about it being CID, international arbitration, or UNCITRAL. No, they just say that they give their irrevocable consent to international arbitration. Do you believe that in that case there wouldn't be consent either because they're not referring to specific rules? I believe there is a consent. The problem, well, no, first, not under the UNCITRAL rules. One could interpret it as consent. It would be under the hypothesis of consent. The problem is perhaps a breach. Supposing that there is a mechanism for this, because when you have that kind of a sentence or phrase, consent to arbitration, and the sentence ends there, there can be many interpretations, but in principle, it's read as an obligation. And it could even be interpreted under the international law system. Another state could demand of the counterpart state that it comply with that obligation. But in any event, we are at a level of international law that is two states. Well, I'm talking about, says the president, a free trade agreement or an investment treaty, one that has a chapter on investment where it says the states that become respondents give their irrevocable consent to arbitration. Let us say it's a treaty between state A and state B, and they say we give irrevocable consent to international arbitration, but they don't specify if it's ICC arbitration, if it's Stockholm arbitration. It just says arbitration, international arbitration. Does that mean there's consent? It can be read as consent, but how can one enforce that consent? The corollary of the obligation, it has to be. If it is an obligation that is assumed in a treaty, however you want to look at it, can only be demanded by the other state, because you cannot demand compliance of an obligation in international law other than by another state deriving from a jurisdiction may know about obligation between states, even if it is in the clause on dispute settlement between the states. If you have it like that, just in the way you have expressed it, because that is, after all, your hypothesis. May I add to this answer? We would then be in a context where there would be what I would call a truncated consent. What I'm trying to say is, let me take those words back. Let me start again. The clause, as presented by you, Professor, would have to be interpreted, as my colleague Gabriela pointed out, that what did the contracting states want to say with that? You need the forum. You need the forum so that that reference can be given effect. It's somewhat similar as to what happens in many bilateral investment treaties copied from the free trade agreement NAFTA that has that kind of a provision. However, it does refer to a number of fora with applicable rules to be implemented at that forum in particular. My question, and you have said what you think, although it doesn't necessarily respond to my question, but the question focuses on the fact that as a petition of principle, you're saying that it is necessary that a specific forum be mentioned in order for there to be consent. What I'm saying is that if in an investment treaty, it just says that the states give their irrevocable consent to international arbitration, and I'm going to suppose that afterwards, and I'm not going to continue, but there might be some norms that make it possible to identify the specific point where the arbitration is going to go. Whoever begins the procedure will have to raise it, and the other party will accede or not. And then one would have to determine which party is right. But that's getting out of the issue. My question is very specific. If in the states have given their irrevocable consent, is there any consent, yes or no? Dr. Alvarez Avila says in principle, yes. But I think the answer is clear. If the states have said we give consent to international arbitration, they've given it then. Then it's a problem to identify the specific forum. But could it be the case or not? Yes, perhaps. But not only to specify the forum, which is something very specific to that forum, but the problem is the enforceability or the corollary of that obligation. The point I'm making is that is it deemed an obligation? the counterpart that can enforce that obligation in international law is the other state. And if it does not become effective, then it could be a treaty breach.
Rephrase my question. Delete paragraph 2. Just delete it. Does that give us consent to arbitration?
A un arbitraje con UTMI.
Uncitral arbitration, or is it in abstract? That's important.
Institution, you could say, there could be a view that if you delete paragraph 2, you have consent to arbitration, and then it's kind of up to the parties to work it out. Now, they either work it out and agree to an institution, that may or may not happen, but if they don't, then you could arguably just default to, you've got to build your tribunal and your rules like a pure ad hoc situation. So in going into that, if a claimant, an investor, I'm not in a state-state scenario, I'm in an investor-state scenario. In an investor-state scenario, a claimant then approaches the state and says, I'm looking at Article 13.1, and that's where it stops. And that gives me consent to arbitrate. So let's get going, Ministerio de Justicia. How are we going to do this? And so that's the question. Does the consent exist at that point?
Y ahí estamos trabajando bajo la hipótesis de
We work under the hypothesis of paragraph 1 of Article 13, which is different from the hypothesis presented by the chairman. If we stop here, as Claudia explained in her closing argument, that paragraph doesn't say how to implement those three options. For international arbitration, how to implement that option is in the second paragraph. For the other two is the applicable law. The national courts, and that's national legislation. I'm sorry, Professor, but even for international arbitration, because in your hypothesis we assume that the second part does not exist. We suppose it says national courts, local arbitration, and international arbitration. So we need consent. Even if you call the Ministry of Justice, where is consent?
A set of rules or a process? Like, why would it be lacking in... Why would there be under international law a lack of consent if there had been clear and unequivocal consent to arbitrate? Because when you say consent to arbitrate, we don't always finish the sentence consent to arbitrate pursuant to the rules of blah, blah, blah. We just say consent to arbitrate.
Pero ahí ya no estamos hablando del supuesto del artículo 13.
But then we're not talking about that hypothesis in Article 13.
I'm saying if you just had Article 13, paragraph 1, and take out paragraph 2, you're saying there is not consent under international law in that circumstance?
Lo que es que para nosotros,
for us, in those circumstances with paragraph 1, we do not believe that there is consent. There are three options not implemented. So 3 options not implemented.
Argument at this 11th hour. So let's assume a slightly different proposition for Article 13, paragraph 1. Imagine Article 13, paragraph 1 just refers not to 3 options, but just to international arbitration. Mm-hmm. Would that be consent under international law?
Bueno, ahí creo que es similar a...
It's similar to what you were saying. Instead of having only 1, you have 2, although the wording was a little bit different. But I think that the answer would be similar. Whether that is consent to international arbitration, period, it's like an obligation assumed that in any case if it does not become effective somehow, it would have to be an obligation state to state with its corollary. Our reading of, and now it's not paragraph 3 anyway, we're now referring to paragraph 3.
Sorry, just a couple more. And I'm sorry, we haven't given an opportunity to Claimant to respond. If you want to respond to my question at all, or...
I believe if we eliminate paragraph 2, it's the hypothetical, correct?
Yes.
I believe if we eliminate paragraph 2, we leave paragraph 1 as is, we continue to say that's consent, period, full stop. If we eliminate the options, the laundry list of options, obviously, and you leave the rest intact in paragraph 1, I apologize. Paragraph 1, there's consent. And I believe if I understood correctly, my colleagues from representing the sovereign, they referenced that, well, if somehow under the hypothetical, you didn't proceed to arbitration, that would be a violation of some sort. Well, if it's a violation, then arbitration was mandatory. So it's tantamount to consent. It is consent.
Okay, thank you. I'd like to propose one other perception, and I'm going to use an analogy, if I'm borrowing from Professor Boylan's inspiration from earlier today, and that is trying to employ a scenario from paragraph 2. Paragraph 2 starts from the position that you are in an international arbitration, and it gives you, I've been thinking, looking at this room, you have 2 doors, and you can go through the left-hand door or you can go through the right-hand door. Now, my understanding of your argument earlier was that you do not have to go through either door. That's how it understood your interpretation of the options, whether these are options that you do not have to take. Did I misunderstand that argument?
Lo que pasa es que podrán acordar por el
may agree because of the verb is an agreement of 2 parties that are singing, that are dancing together. It's not that individually each chooses a door. They both have to leave through the same door if they decide to exit. There is the option, of course, that somebody does not want to use the door. They may, because they may agree. They may decide not to exit the room.
If we're in the room, and in paragraph 2, first sentence, we're in the room, how do we get out of the room? Because if we are left with having to agree and there is no agreement, you are still in the first line of paragraph 2. You are in an international arbitration.
Es que todavía no se inició.
Arbitration has not started yet.
If it says when.
Cuando se, es cuando se refiere, ¿no? Cuando es referido.
When the dispute is referred to international arbitration, and that's how I read the implementation.
You would say that, and I know I'm presupposing certain arguments which you have not conceded, which is that it is still a conditional as to whether or not international arbitration has happened, because you say that that choice still has to be made. So you would presumably object to my hypothesis of you're even in the room. You're not even in the room.
No.
Okay. I have 2 more questions. Sorry. I'm sorry. The penultimate question goes, and I'm sorry, I haven't given claimants an opportunity to respond.
I think they're in the room. I'll leave it at that.
Okay. This next question goes to the 4th of May 2018 correspondence, and there's the reservation of rights. And what I'm interested in is, does that prevail in your position, notwithstanding the 18th of May reference to uncitral. On the 4th of May, there was a reference to, we have a broad reservation of rights. And then on the 18th of May, there's a reference to an agreement to the uncitral rules of 1976. And so my question is, does that broad reservation of rights, is it your position that that sort of carries through, notwithstanding the reference to an agreement to the uncitral rules? And therefore, is that your basis for saying there was, for example, a reservation for jurisdictional objections?
Sí, o sea,
Yes. The question or the issue here is that reserve of rights covers the consent to uncitral arbitration differently from which rules will be applied. And that's a procedural issue, so much so that this would not be posited if there were no other versions, or if the counterpart hadn't said that another version would be applied. That issue would never have come up. So we're not talking about consent to uncitral arbitration in keeping to Article 1.
Claimant, do you want to respond in any way? Okay. Thank you very much. No further questions from me.
So, we don't have more questions. No tenemos más preguntas.
We have no more question, and unless the secretary tells me otherwise, we have to talk about the future. What will be our future? The future of the verb to be. Before we talk about the future, can we talk about past and present? And it will be only 1 minute. There was reference to my words in the opening words of the claimant, and I would like the tribunal to take into account my words in Spanish, because I found an error in one of the references made in English, and that is the words in which my colleague underscores something I said. It's slide 22. In Spanish, it is correct. I go back. Let's talk about what we're going to do. We had talked previously, before this hearing, about the possibility of submitting post-hearing briefs. The tribunal believes that at this point, with all this discussion, those submissions would not be necessary. As a tribunal, we would like to know whether the parties have another opinion or whether they agree with the tribunal. These questions that we've just asked at the end, I think have cleared the last questions we had, clarified the points we had, and we believe that post-hearing briefs would be a repetition and to see things that we've seen several times. Claimant, we agree they're not necessary. Respondent, we agree too. We do not believe they're necessary. If that is the case, then we can end this session. The tribunal will deliberate, will take the most fair decision. We have followed this hearing and the whole procedure, giving it a lot of attention, with a lot of pleasure. There was some riffraff, but everything was maintained in the normal channels, sometimes even funny. Thank you all for that. And I would like to know, I would like you to say now, we don't want to preclude any rights, but are you in agreement with the way in which the tribunal has dealt with this hearing, giving both parties the possibility to make their points? Yes, Mr. Chairman, and thank you very much. Very happy. Thank you very much for your time. So we are the ones who thank you. We would like to thank all of those who've participated, not only the representatives, the councils, the witnesses, the experts, of course, interpreters, magical transcriptions. David treated us a little bit badly, but we forgive you. Especially, would like to thank our secretary that really helps us a lot to be able to do what we have to do. We hope to be as agile as possible so that we can give you a decision about this point, which is so important. Thank you very much, and I will see you soon. Thank you all.